Assalamualaikum warahmatullahi wabarakatuh. Based on our questions, the first issue is whether Nadira, Azlan, Faizal can be held liable for breaching their duty as a trustee under the trust established by the Puan Kamaria in the favour of her grandchildren Alia, Faris and Zara. A breach of trust refers to situations where a trustee failed to carry out the duty imposed under the trustee deed or by operation of law, either through a wrongful act or an omission such as a failure to act. A trustee will be held liable if the breach results in an authorised personal gain by the trustee as established in Regal Hastings Limited and Gulliver, or a loss to the trust property as had in Prof. Dr. Siti Nurmala binti Said Obid and others, and Lembaga Pemegang Amanah Koalisi Islam Malaysia and CIMB Bank Berhad and Maybank Trustee Berhad. As established in Holding Limited and Reference, the basic right of beneficiary is to have the duty duly administered by the term of the trust, instrument and the general principle of trust law. Also, in the case of Tongli and Sherborne, the liability of the trustee is a personal and not vicarious, meaning a trustee is only responsible for their act or omission and not automatically liable for the wrongdoing of a co-trustee. However, in the case of Brick and Stone, the trustee must manage the trust together unless stated otherwise. The trustee who is inactive or lets another trustee act alone can be still personally liable. The court said trustee must take active steps to carry out their duties. We can also look in the case of Haji Ali in Hafsah and Muhammad Zain. Although one of the trustees was a semi-illiterate woman and was excused due to acting honestly and reasonably, another trustee with business knowledge who remained passive was held jointly liable with the defaulting trustee. Moving on, court have consistently taken the view that passive trustee who fail to act when trust property is misused should not be relieved of liability, as affirmed in the case of Syed Muhammad Asad Goff and Roland J. Ferrer. This proves that although liability is personal, trustees are still under duty to actively administer the trust, and failure to do so may result in liability for breach of trust. Moving on, according to Section 35 of the Trustee Act, a trustee is not liable for a co-trustee breach unless the loss is caused by the trustee's own willful default. A trustee is only responsible for money or property that actually received and not for other actions, unless they intentionally caused the loss. Besides that, in the case of Head and Globe, the court held that a retiring trustee can only be held liable for a breach of trust committed by their successor if it can be clearly shown that the retiring trustee knew or intended that the breach of trust will happen at the time of the retirement. In addition, a beneficiary consents to a breach of trust does not prevent other beneficiaries who did not consent from taking legal actions against the trustee. In the case of V. Pauline Statement Trust, for a beneficiary consent to be valid, there must be an adult or sound mind suggeries and must be given that consent freely without pressure from the trustee. Lastly, we can also refer to the case of Nestle and National Westminster Bank, where a breach of duty is only actionable if it causes loss. If an unauthorized investment made a profit, there is no claim, but if it causes a loss, the beneficiary may either adopt it or claim the loss, or ask the trustee to sell it, reinvest properly and make up the loss.
So, moving on for the application part. So, in this case, there are three trustees, which is Nadira, Azlan, as well as Faizal. And the question that need to be answered in the application part is whether these three trustees have breached their duty as a trustee. So, let's move on one by one. So, for the first trustees, which is Nadira, in this case, Nadira have clearly committed the breach of duty as a trustee while managing the trust account or the trust administration. This happened when she have, while managing the trust, she have transferred the money from the trust account, which is 300,000 ringgit from the trust account to her own account. And after transferred that money and mixed that money with her own money, she started to do something with the trust money for her own benefit. This is when she started to renovate her house using the trust money, which is 60,000 ringgit. She started to do a luxury vacation to Europe using the trust account money. She started to pay the private university fees for her daughter using the trust account money, and she started to purchase a new car, which is cost 150,000 ringgit. Use the money that she have transferred from the trust account to her own account. Thus, this all action have clearly shows that she have committed the breach of trust, since she have caused the loss of profit to the trust, and she have used the money from the trust account for her own benefit. And this is aligned with the case of Regal Hastings Ltd and Gulliver, where the court held that any trustees are not allowed to make profit from the trust property or the trust account. And as aligned with the case of Prof. Dr. Siti Nurmala and Lembaga Pemegang Amanah College and CIMB Bank and Maybank trustees, any trustees who cause loss of profit to the trust account will constitute him as a trustee while managing the trust, will constitute her while managing the trust for the breach of duty as a trustee. And thus, in this case, it is clear that Nadira have clearly breached the duty as the trustee while managing the trust, as she already used the money for her own benefit. So moving on for the next part of this application. So under this application, it need to be determined whether the act of one of the trustees, which is Azlan, can be considered as breach of his duty as a trustee. So it need to be noted that in this case, Azlan, one of the trustee, is a businessman with the nature of his work is to travel overseas frequently and cause him to rarely involve with the administration of trust, and thus this have led him to put all burden or to give largely power to the Nadira to administer the trust. In this case, it is clear, as I explained in the first application, that Nadira, who have power largely to administer the trust, have caused loss of profit to the trust and have do something bad to the trust for her own benefit, and thus this action have led to the loss of profit to the trust account. So, referring to the case of Tonley and Sherborne, any improper action that done by one trustee that cause loss of profit or cause misconduct to the trust account can only be held personal and cannot be held liable jointly. And thus here, Azlan have no relation to the action done by Nadira, as by virtue of the principle in this case, the action only be done by Nadira, and only Nadira can be held liable for her own action, and Azlan cannot be held liable. But so in this case, Azlan do not liable for any action done by Nadira. However, there is one of the duty as a trustee that he need to follow, which is as affirmed in the case of Brice and Stokes, that he need to jointly administer the trust. So what does it mean? It means that Azlan have a duty to help Nadira to jointly administer the trust and not put all burden to her. So in this case, the action of putting all burden to Nadira and give Nadira largely to administer the trust, and he himself do not rarely involved with the trust, can be held liable, as the duty as a trustee is to jointly administer the trust and not to put or give the work to any other else and prevent himself or avoid himself from administering the trust. So, as affirmed by Brice and Stokes, the action of rarely involved and not jointly administer the trust can cause Azlan for breach his duty as a trustee. And referring to the case of Syed Muhammad Al-Sagoff and Roland J. Ferrer, Azlan will be held liable for breach of trust, as the duties of the trustee is jointly duties to administer the trust actively. So, in this case, there is a question whether Azlan can raise the defense under Section 35 of the Trustee Act to release himself from the breach of duty as a trustee, and the answer is no. Why? This is affirmed by the case of Sri Haji Ali, DECD, Hafsa and Muhammad Zain, where the court held that even the trustees is not done something bad and only act passively due to he himself have a business knowledge. The court held that he himself will be held jointly liable with the defaulting trustees, even he himself have no willful default in his action. So in this case, the action of Azlan, who rarely involved with the trust and frequently travel overseas, can be said as a passive action from him, as he himself involved in the business field. So, as affirmed by the decision made by Sri Haji Ali, even he himself have no willful default action in himself, but the action of being passive and will lead to and cause the breach of trust to be made by the other court trustees. The court held that he himself will be held liable jointly. Thus, no defense can be raised on behalf of him, as clearly stated by Sri Haji Ali. The passive action by him, even he himself not doing anything, it can be considered as willful default. So let's move on for the last application in this issue, and the issue that need to be answered in this application is whether Faizal have committed the breach of duty as a trustee while managing the trust. So in this case, it need to be noted that Faizal have resigned and vacate from his office on June 2024, and the action that being done by Nadira, which lead to the breach of duty as a trustee, only be done on July 2024. So, in this case, it need to be proven that Faizal, during his time in his office, already know that Nadira have intention to do something bad to the trustee to the trust, and want to cause the loss of profit to the trust. But he, instead of lodge a report and do something to avoid that action to happen, remain silent and thus vacate or stepping down from his duty. So in this case, it is clear that Faizal already know that Nadira have intention to do something bad to the trust and to cause loss of profit to the trust. But instead of him doing something to avoid Nadira from doing that, he stepping down and remain silent from his duties. Thus, in this case, it is clear that even all the action being done by Nadira is happened after Faizal have retired. But since Faizal already know during his time at his office that Nadira have intention to do that kind of thing, or to do something bad for the trust, which I already explained in my first application. Thus, Faizal will also be liable for the breach of trust or breach of duty as a trustee, as this is aligned with the decision made by the head and group, which states that if the trustee already know before he resigned that the other trustees want to do something bad for the trust, but he remains silent and choose to stepping down or resign, then he will also liable for the breach of trust and lead to him to liable for the breach of duty as a trustee. So for the conclusion part, all in all of the trustees, which is Nadira, Faizal as well as Azlan, have breached their duty as a trustee, with first Nadira have done something, or her action have caused loss of profit to the trust account, and she have used the trust money for her own benefit, and this have led to the breach of duty as a trustee on her part. So for the Azlan part, in this case, Azlan have a duty to jointly administer the trust, but he failed to do so, and he cannot raise the defense under section 35, since by virtue to the case of Rihaji, the action of passive or not active in the administration of trust due to the business nature will constitute a breach of trust, and thus lead to the breach of duty as a trustee. And lastly, for Faizal, in this case, Faizal, in which he resigned before the action of Nadira to cause a loss of profit to the trust be made, he already know that Nadira have intention, but he remain silent, do not want to take any action by lodge a report, and stepping down constitute him to be breach his duty as a trustee. And thus, from all of the explanation above, these three trustees have breached their duty as a trustee.
The second issue for our group is whether there are any possible defences under Section 63 and 64 of the Trustee Act 1949 that is available for Azlan, Faizal and Nadira. Next, for the law for the second issue is there are two possible defences that a person can use to exclude themselves from liability after breaching a trust. The first defence can be seen under Section 63, where it states that if a person has acted reasonably and honestly while managing a trust, they can exclude themselves from liability. There are several conditions that need to be fulfilled in order for a person to successfully raise the defence under Section 63. The conditions can be seen in the case of Marsden and Regan, where the first condition is the trustee must prove that they has acted honestly without a selfish motive and a genuine intention to benefit the trust. Secondly, the trustee must prove that they has acted reasonably with the same care that a sensible and responsible person would do in managing their own affairs. Thirdly, the court must find it fair to exclude the trustee from liability, taking into account both the trustee's action and how others were affected. In Malaysia, the condition is stated in the case of Haji Ali bin Haji Muhammad Nur, Hafsah bin Nasirah and Muhammad Zain, where it was held that the burden was on the trustee to prove that they has acted honestly, reasonably, and it would be fair for the court to exclude her from liability. In the case of Koh Pei Ian and Chu Sian La, the court held that the trustee will not be liable due to loss of property for proven robbery if the trustee has care for the trust property as they would care for their own. Moving on to the application of Section 63 of the Trustee Act 1949. Based on the facts of the question, the defence under Section 63 is not a defence that can be used by Nadira because she is not acting as a reasonable and honest trustee, as she is the one who takes the money for her personal use. But the other co-trustees, such as Azlan and Faizal, has not been acting dishonestly because they are not the one who takes the money. However, based on the facts of the question, they has not been acting reasonably. According to our case, Azlan is said not to act reasonably because he didn't administer the trust and he also did not perform his duty as a trustee even though it is a joint duty. This is because he often travel abroad and he is too busy to manage to do a daily management of the trust. This shows that Azlan has not been acting reasonably and cannot raise the defence under Section 63 as per the case of Haji Ali. On top of that, Azlan has permitted Nadira to take the lead to manage the trust. This shows that he is not acting reasonably because he just entrusts Nadira to take care of the trust all by herself. Any reasonable person who is in Azlan's position will make a great effort to manage the trust with a great care to ensure that the trust is being properly taken care of as if it is their own. Since Azlan did not do this, he cannot raise the defence under Section 63 of the Trustee Act 1949 as per the case of Marsden and the case of Koh Pei Ian. Moreover, Faizal is also considered not to be acting reasonably due to the fact that he knew Nadira's intention to use the trust property for her personal use. Faizal should have reported or investigate the matter further just like any reasonable person who in his position would do. Instead, he just resigned to escape from any possible liability. Since he knew that the trust property will likely to suffer a loss but didn't do anything about it, he is said to not to be acting reasonably as a trustee. Hence, he cannot raise the defense under Section 33 as explained in the cases above. Here, both Azlan and Faizal might not be able to use this defense because they has not been acting reasonably. This is because their action does not meet the standard or expectation in trustee when performing their duties. Hence, both Faizal and Azlan might not be able to successfully raise the defense under Section 63 of the Trustee Act 1949.
Moreover, Section 64 of the Trustee Act 1949 provides a defense for trustees who have committed a breach of trust, provided that the breach occurred with the consent or agreement of a beneficiary who is of legal age and sound mind. The principle behind this section is that beneficiaries who voluntarily and knowingly participate in or consent to a trustee's wrongful conduct should not be allowed to later hold the trustee liable. So Section 64, subsection 1 of the Act states that if a trustee breaches trust at the instigation, request, or with the written consent of a beneficiary, the court may order that all or part of the beneficiary's interest in the trust estate be impounded as indemnity for the trustee. This means that the court can order the consenting beneficiary to bear the financial loss resulting from the breach to protect the trustee from liability. According to the case of Ramasamy, anak lelaki Kamachi and others, and Tayalan, anak lelaki SK Salanianandi and 63 others under Section 64, the court has the discretionary power to make the beneficiary indemnify a trustee where the breach was committed with consent in writing or at the request of the beneficiaries. However, according to the case of Re Somerset, the court will not exercise its discretion unless it is proven that the beneficiary understood the nature and consequences of the breach. This means that the beneficiary must have had full knowledge of the material facts when they are giving consent. Moreover, according to the case of Life Association of Scotland and Siddal, the court stated that a beneficiary who consents to or participates in a breach is barred from later suing the trustee for the breach. This means that a beneficiary cannot approve a transaction and then proceed to challenge it later on. However, it is to be noted that the consent of the beneficiary in a breach by the trustee does not represent the consent of the other beneficiaries in that trust. This means that other beneficiaries who did not consent to the breach can still take action against the trustees for the breach of trust. Lastly, a beneficiary may lose their right to sue a trustee if, after the breach, they acquiesce to it, or in other words, they accept it reluctantly but do not protest to it. In the case of Stafford and Stafford, the court held that if a beneficiary's conduct shows approval or acceptance of the trustee's actions, then that conduct may be treated as implied consent, therefore not allowing them to take action. So in our case, Alia, Faris and Zara are the beneficiaries. According to Section 64 of the Trustee Act 1949, they must consent to breach by the trustees in order for the trustees to seek defense under this section. So according to Section 64, subsection 1 of the Act, the beneficiaries must give consent in writing or request or instigate a breach. In our case, even though Faris and Zara had knowledge of what happened, it cannot be said that they gave consent since they did not do so in writing. This is the same for Alia since she never consented to it nor did it in writing. There is also no evidence that they requested or instigated the breach. Moreover, according to the case of Re Somerset, Alia did not have knowledge of the breach at the time it occurred. Therefore, it is unlikely that the trustees can successfully invoke Section 64 against Alia, as there is no evidence that she had knowledge of or consented to the breach. Faris and Zara, on the other hand, did have knowledge of the breach. This means that initially, the beneficiaries can sue the trustees. However, according to the case of Stafford and Stafford, even if Faris and Zara knew about the breach, they would still lose the right to sue since they showed acquiescence because they did not actively protest the breach and they just kept silent about it. Therefore, only Alia can sue since she did not have knowledge of the breach, and this aligns with the judgment in the case of Life Association of Scotland and Siddal. In conclusion, according to Section 64 and the case of Ramasamy, Azlan, Faizal and Nadira cannot rely on the defense under Section 64 as there is no evidence that the breach occurred at the instigation, request or with the informed consent of the beneficiaries, particularly Alia who had no knowledge of the breach at all. In conclusion, Azlan, Faizal and Nadira cannot rely on the defenses under Section 63 and 64 of the Trustee Act 1949 since the requirements for both of these defenses cannot be met.
Moving on to the third issue is whether Alia can recover the misappropriated trust property or its value from Nadira after Nadira transferred 300,000 ringgit from the trust account to her personal account and used it for a variety of personal expenses and acquisitions. Under Malaysian trust law, trustee must act in the best interest of beneficiary. Misusing trust asset is a breach of trust and beneficiary can seek equitable tracing to recover the property or its substitute. There are three conditions need to be satisfied for tracing to be succeed. The first one is there must be initial fiduciary relationship between the parties. In Khalid Estate, solicitor had money on trust for a client and wrongfully mixed it with his personal account. The court recognized the fiduciary nature of the relationship, which is a necessary foundation for invoking equitable and tracing remedies. Next, moving on to the second condition is the trust property must be in traceable form. In the case of Redeploy, the court addressed the distribution of trust fund to a charity under a will that was later declared invalid. While the funds were originally traceable, the court held that where the property had been dissipated or transferred to innocent third party, it became untraceable. Next, moving on to the last condition is tracing must not result in an equitable outcome. In the case of Sinclair and Brookham, the court declined to permit tracing into the hand of depositor of an insolvent building society, reasoning that allowing recovery in that context will proceed unfair result. When property is purchased entirely with unmixed trust fund, the beneficiary is entitled to assert a proprietary claim over the property. They may choose either to recover the asset itself or to impose a charge over it to secure repayment of the misapplied trust fund. In contrast, when trust money is mixed with the trustee-owned fund, the rule in the re-held estate limit the beneficiary claim to a charge for the portion of the trust money used. This approach protects the interests of beneficiary without unfairly disadvantaging the trustee right in the mixed fund. However, where trust funds are used for consumptive purposes, such as the payment for personal service, charitable donation, or expenses that do not result in tangible or traceable assets, which the fund are considered dissipated and therefore untraceable, courts are generally unwilling to permit tracing in such instance, as doing so will lack both practically and fairness in equality.
So in our case, the trust relationship between Alia, who is the beneficiary, and Nadira, who is the trustee, is undisputed, and Nadira clearly breached her fiduciary duties by transferring 30,000 ringgit from the trust account into her personal account for her personal use. This satisfies the first condition for tracing. The various transactions must be assessed for traceability. First, the 60,000 ringgit used to renovate Nadira's kitchen constitutes a consumptive use, as the money was spent and not used to acquire a traceable asset, resulting in dissipation and therefore untraceable, as established in the case of Redeploy and supported by traceable property principles. Second, the 100,000 ringgit used to purchase shares under Nadira's own name presents a different issue. Although shares are intangible and generally untraceable as property, as held in Redeploy, they have since increased to 135,000 ringgit. As a trustee, Nadira cannot retain profits gained from misuse of trust property, so the 35,000 ringgit profit is recoverable under a constructive trust, and she must account to the beneficiaries where this is in line with the principle in the case of Re-Hallis Estate and traceable property rules. Third, the 50,000 ringgit spent on a luxury vacation was a consumptive use and is therefore dissipated and untraceable. Fourth, the 30,000 ringgit used to pay university fees for Nadira's doctorate is a service expense that did not result in an identifiable asset, making it untraceable. Fifth, the 60,000 ringgit donation to an NGO was a transfer to an innocent third party who received the funds in good faith, and as affirmed in the case of Sinclair and Broham, tracing is not permitted in such cases as it would lead to an inequitable result. Finally, the 150,000 ringgit used to purchase a car which is bought directly from the trust account and registered in Nadira's name is fully traceable, as the entire amount originated from unmixed trust funds and are used to acquire a tangible asset. Alia may either recover the car itself or impose a charge over it to reclaim the 150,000 ringgit, following the rule in Re-Hallis Estate.
Okay, all in all, Alia can recover part of the misused trust property, specifically the value of the share and the car, through equitable tracing, but the remaining amount are untraceable due to dissipation or transfer to innocent third party. I think that's all from us. Thank you.